get started. I'd like to welcome you to Hinshaw's 25th Annual Labor and Employment Seminar. We have a take place without a legal disclaimer. The information presented today is not intended to and does not constitute legal advice, recommendations, or counseling under any circumstance. You should not act or rely on any information provided without seeking the advice of an attorney licensed to practice in your jurisdiction for your particular situation. In addition, the information presented during this session does not necessarily reflect the opinions of our clients. Again, thank you all for joining us. Let's get started. It is my great pleasure to introduce today's speakers, David Dalby and Melissa Schaefer. David is a partner with Hinshaw & Culbertson and has a diverse trial background. Has a diverse trial and litigation practice representing attorneys and other professionals, business entities, and private employers, including financial institutions, nonprofit corporations, securities firms, associations, and insurers. David has prosecuted and defended lawsuits in both state and federal court concerning employment and disability discrimination, wrongful termination, wage and hour claims, professional liability, personal injury, bankruptcy, insurance, and contract disputes. He also serves as counsel to private employers concerning human resource risk management issues. Melissa Schaefer represents her clients in labor and employment matters in addition to workplace injury litigation. She defends employers facing a wide range of employment disputes, which includes extensive experience with matters involving discrimination, harassment, retaliation, wrongful termination, and wage and hour violations. She also counsels employers about their employment policies and risk management decisions in addition to litigation and minimizing employers' workers' compensation claims. Melissa is the co-leader of Hinshaw's National Labor and Employment Practice Group. She also manages the Labor and Employment Group in Los Angeles and serves on the firm's Associate Hiring Committee and the Executive Committee. And now I will turn the presentation over to Melissa Schaefer.
Hi, everyone. Welcome to our first annual virtual seminar. I hope you all are doing well out in Zoom land. I want to start off our presentation today by saying that trying to put a year's worth of information into 1 hour is near impossible. So this seminar is by no means meant to be inclusive because we have to touch upon so many different items. So if you do have any questions or things after we've talked about a topic for the brief time that we have allotted, please let us know and we'll do our best in order to address those questions. Otherwise, get ready because it's going to be a fast-moving presentation. Next slide. We are starting off our cases with the United States Supreme Court cases. The first one we're going to talk about is Bostock. This case represents a combination of 3 different cases. Bostock itself was out of the 11th Circuit, whereas Zarda was out of the 2nd Circuit and Steffens was out of the 6th Circuit. Now, some of you may have heard about the Steffens case, which was the worker who was at the funeral home who wanted to, was a male and wanted to transition into female. And the other 2 cases involved termination of employees for being gay. The 3 cases were consolidated to address the issue of sexual orientation or gender identity. And on June 15th of this year, the Supreme Court, by a vote of 6-3, ruled that the federal law prohibits employers from terminating employees because of their sexual orientation or gender identity. Obviously, this was a big step in order to put another category in Title VII. And the 6-3 was a surprise to some based upon the justices that did issue the opinion. Next slide.
The next case we're going to look at is the case of Our Lady of Guadalupe School versus Morrison Berry. This case involved 2 lay teachers who were employees at religious schools in the Los Angeles area. They both were terminated and they filed suit, of course. The district court dismissed their claims, but however, the 9th Circuit reversed the district court, finding that the application of the ministerial the ministerial exception to the First Amendment did not apply to them because they were simply school teachers who were teaching from curriculum from books. However, the Supreme Court held that they were subject to the ministerial exception, and their schools where they work could not be sued, even though the Ninth Circuit was not impressed with the level of teaching and their commitment, or having to have a commitment to a particular faith. The Supreme Court held that the ministerial exception did apply to them in their role. Justice Sotomayor was concerned in her dissent about how far this ministerial exception could be applied. On the other hand, religious organizations are going to have to make sure that the guidelines as to what the employees are doing in terms of teaching within the faith are made clear to them. Next slide, please.
The next Supreme Court case we're going to talk about is Comcast Corp versus the National Association of African American Owned Media. Now, this case involved Entertainment Studios Network, which operated 7 television networks and was owned by an African American entrepreneur. So they had entered into negotiations with Comcast that ended up failing. And afterwards, they cited, Comcast cited lack of demand for the programming that the media outlet had offered, but ESN did not believe that was the case and thought it was because it was African American owned. So they filed suit, and they claimed Comcast systematically disfavored 100% African American owned media companies. And they raised a claim under Section 1981, which basically guarantees all persons to the same right to make and enforce contracts as enjoyed by white citizens. Now, what ended up happening here is they had an issue of what kind of standard to be applied. And then on March 23rd of this year, the United States Supreme Court decided that the but-for causation standard applies to claims of racial discrimination raised under 42 USC 1981. So because the court had utilized the wrong standard, the Supreme Court remanded it back for further proceedings to address the correct standard to review. Next slide.
In this Supreme Court case, Babb versus Wilkie, Secretary of the VA, the Supreme Court expanded the protections of the federal workers under the Age Discrimination and Employment Act of 1967. The Supreme Court held that the test as to whether or not the act had been violated depends upon a motivating factor test as opposed to a but-for test, which obviously is the motivating factor test is a less stringent test than the but-for test. For federal employees, an employer is liable if the employee can prove that age tainted the making of the personnel action. This applies to federal employment only, not private employers. And the but-for test still applies when obtaining remedies such as back pay, compensatory damages, reinstatement. Excuse me. Next slide.
Moving into some other cases that we thought were quite pertinent, the Equal Pay Act came out in the case of Rizzo versus Jovina. And this one's a Ninth Circuit case, so applicable to California and the West Coast. Now, a quick background on this one was there was a female math consultant. This is actually out of the Fresno County area. And she applied for this job, and she had come from a different employer. Now, the county of Fresno set salaries based upon a pay step system. And so when she provided her previous salary, they looked at the scale of where she would fit, and then they would put her into the next category. Well, she came in below, and so they put her in tier 1 of their pay step system. And as her employment moved on, she learned that her male counterparts and colleagues made more than her. So she ended up filing a lawsuit, of course, and at the trial court level, the county moved for summary judgment, and this was denied, noting that the prior salary can never alone qualify as a factor other than sex. Now, what was interesting here is when the case went up on appeal, it was decided, but 11 days before the opinion issued, one of the Ninth Circuit judges died. And so even though they had ruled in favor of the plaintiff, the decision, the county appealed it up to the Supreme Court, and they remanded it back, saying that because of the death of the judge, they needed to redo it. Next slide. When it went back up, excuse me, this Ninth Circuit did not change. Back one, there you go. The Ninth Circuit did not change its opinion. They basically said and maintained their prior decision that setting wages based on a previous salary just perpetuated the history of sex-based wage discrimination, because the whole point of the Equal Pay Act was to eradicate women making less. But if you utilize the woman's last salary in which to determine her next salary, it could not do anything but. So this one is interesting because the Ninth Circuit joins the 10th and 11th Circuit, but the 7th and the 8th Circuit differ, noting that reliance on prior salary does not by itself violate the act. So this could be an issue that will continue to rise up and possibly make the Supreme Court docket. Next slide. Another interesting case involving religious accommodation was the EEOC versus Walmart case. Now, in this case, the candidate applied for an assistant manager position at a 24-hour Walmart. And I do think the 24-hour part of the employment position is very key here. The store itself had 1 store manager and 8 assistant managers. Now, this candidate was offered the job, and upon the offer, he advised Walmart that he could not work on Saturdays because of his religion. At that point, Walmart withdrew the offer of employment, but they offered the candidate a non-managerial position that would allow him to take Saturdays off, as well as providing human resources assistance in his job search. He filed suit alleging religious discrimination and retaliation under Title VII. Now, we all know that Title VII prohibits a prospective employer from refusing to hire an applicant in order to avoid accommodating a religious practice without undue hardship. But this is what Walmart went ahead and proved in court. They argued the undue hardship. Their summary judgment motion was granted at the district court level, having found that Walmart offered a reasonable accommodation and that accommodating the candidate's request to not work Saturdays would have resulted in an undue hardship because none of the other assistant managers were given that same benefit. In addition, they did not have to create a permanent shift assignment to accommodate the inability to work on Saturdays. And again, I do believe that 24-hour Walmart, the 24-hour store really comes in play here. I don't know if you'd have the same result if it was a normal 8 to 8 hours, whatnot. That's something that I just don't know if it would have been determined to be the same. Next slide.
We're next going to look at the Families First Coronavirus Response Act that was passed earlier this year. The act is effective from April 2nd, 2020 to December 31st, 2020. Next slide, please. Generally speaking, the Act provides employees that are covered employers are eligible for two weeks up to 80 hours of paid sick leave because of the employee is quarantined because of the COVID-19 symptoms. 2 weeks paid sick leave at 2/3 of the employer's regular rate of pay if an individual subject to quarantine, because they are an individual subject to quarantine or because of a child care whose child care provider is closed or unavailable for reasons. And then up to an additional 10 weeks of paid expanded family and medical leave at 2/3 of the employer's regular rate of pay. Next slide, please. The following slides that you can look at later after the presentation discuss who is covered, what they're required to provide. Next slide, please. And next slide, please. There are exemptions to who is covered by the FFCRA. There's a health care provider exemption. There's also a small business exemption for fewer than 50 employees. Next slide, please. These two exceptions, excuse me, next slide. To meet the exemption, having to provide this type of leave, the business must be able to establish that leave of one of the individuals would result in expenses or financial obligations that would cause the business to cease its normal operating capacity. Another exemption is if the absence of the employee would entail a substantial risk to the financial health or operational capabilities of the business because of that particular individual's specialized skills, needs, or responsibilities. And a third exemption to the FFRCA leave would be if there are insufficient other workers, replacements for that particular individual who can perform that task. Next slide, please.
So many of you may have heard that with the Department of Labor, they issued their final rule, but then the federal court in the Southern District of New York struck down 4 key aspects of it, including the work availability requirement, the definition of healthcare provider, the employer agreement for intermittent leave, and documentation requirements. Next slide. On September 11th of 2020, the DOL then issued a temporary rule, amended rule, that went into effect on September 16th, 2020 because of these issues. So in reference to the work availability, the temporary rule reaffirmed that the paid sick leave and expanded family medical leave, collectively what we're calling the FFCRA leave, can only be taken if the employer has work available for the employee seeking FFCRA leave to perform. It may not be taken by an employee who, if not on leave, would be subject to a temporary or permanent layoff for lack of work. Now, in reaffirming its rules, the Department of Labor responded to the district court's criticism in this New York case by providing a more detailed rationale for its limitation. It also clarified that this leave would apply to all grounds for which an employee may seek FFCRA leave. Previously, it limited to only 3 of the 6 reasons, which was one of the issues that the New York case saw. So in reference to the, next slide, sorry. In reference to the work availability, as I noted, it clarified the various issues that the New York court had and clarified it and added these additional rationales and justifications that we just discussed. Next slide. Now, the requirement cannot be used by an employer to avoid granting FFCRA leave by purporting to the lack of work for an employee. Now, with regards to this requirement, it needs to be understood in the context of the applicable anti-retaliation provisions, which prohibit an employer from discharging, discipline, or discriminating against employees for taking any leave. Next slide. The second clarification that the DOL did because of the New York case was the definition of healthcare provider. Now, in the EFMLA and PSL, they both provide a definition of the healthcare provider, but basically the FFCRA adopted the definition that the FMLA did, which defined them as a doctor of medicine or osteopathy who practices medicine, surgery, or any other person that is capable of providing healthcare services. The issue that the New York case found was that the rule actually provided a broader definition and included anyone employed at any hospital, nursing facility, retirement facility, nursing home, home healthcare provider, or similar institution. So it basically went for the employer versus the employee and what the employee did. And the revised rule adopted a narrower definition of healthcare provider. Next slide. The new definition means somebody who's capable of providing healthcare services. And they went on to define this as someone who is employed to provide diagnostic services, preventive services, treatment services, or other services that are integrated with and necessary to the provision of patient care, and that if not provided would adversely impact patient care. Now, basically, the intent of this change was so that they could include positions such as IT, maintenance, human resources, food service workers, records managers, people in billing. Basically, it no longer mattered if the employee was simply employed by an entity that provided home healthcare services, but they actually needed to be the one to provide the healthcare services. Next slide, please. This slide just provides some additional information with regards to who these people would include. Next slide. The third issue that the New York case took issue with and that the DOL clarified is regarding the intermittent leave. Now, the original rule permitted an employee to take FFCRA leave intermittently only if the employer and employee agree and only under a subset of qualifying reasons. Now, the Department of Labor clarified that an employee may not take FFCRA leave on an intermittent basis without prior employer approval. Now, after the New York case attacked this final rule, they provided the additional explanation in order to clarify why this was the way what their intent was behind it. The explanation more soundly ties the Department of Labor's requirement that an employer consent to intermittent FFRC leave to the FMLA's intermittent leave provisions. Now, there is one exception. Next slide, please. The exception involves the hybrid school plan. So the FFCRA leave is full day increments to care for a child whose school is operating on an alternate day or a hybrid basis can be considered an intermittent leave. So what this means is if the school is actually open, they can take a day of leave. But if the school is officially closed the next day and the child is unable to go because it's closed, intermittent leave is not needed because the school literally closes, as that term has been used in the FFCRA as well as under 29 CFR 826.20 and opens repeatedly. So that's the one exception that they put into the rule to clarify the intermittent leave. Next slide. The FFCRA permits employers to require employees to follow reasonable notice procedures to continue to receive paid sick leave after the first work day. Now, in reference to the New York case, as well as the DOL rule, what they ended up doing is saying that a person is to give as much notice as possible, but sometimes advance notice is not actually available. So what they explained is that advanced notice is not required if the need for leave is immediate or unexpected. Then they need to give the most reasonable or foreseeable notice that they can give. So the example given would be if an employee becomes aware on Monday that the child's school will be closed on Tuesday, they need to give as much notice on Monday as they can that they'll be taking the next day off. So they tweaked the advance notice provision a little bit in order to make it more reasonable and understandable. Next slide.
This is a short EEOC update. The EEOC rendered guidance earlier this month recognizing that there is an opioid disability or opioid use disorder, OUD. And in that regard, the EEOC issued guidance to employers concerning dealing with an opioid disability. It evaluates the request for accommodation based upon is the individual using an opioid because of a prescription, because of a medically assisted treatment, or is the use unlawful? Essentially, the opioid guidance by the EEOC is that legal use of opioids for treatment, medically assisted treatment, prescription, can require a reasonable accommodation. Illegal use of opioids is not a justification for a disability accommodation, even if the individual has an opioid use disorder. The analysis, as usual with the reasonable accommodation, is when evaluating it, is it going to impose a significant cost or an unreasonable burden on the operations of the employer or fellow employees? It is significant, however, that the EEOC has recognized opioid use disability. Next slide, please. These are examples of the employee screenings that can take place. Next slide, please. COVID testing is permitted. However, antibody testing is not, because it has not been determined to be accurate enough. Next slide, please. As with areas involving the EEOC and reasonable accommodation, the employer has to be aware of the obligations of the ADA, but also aware of non-discrimination and reasonable accommodation requirements remaining in place. Next slide, please.
We're now going to touch upon a few DOL updates before we move into California-specific updates. Next slide, please. One of the things the DOL has done recently is issued some new FMLA forms. This is a link that you can utilize in order to find them. Now, the DOL forms remain optional, but they include information that must be communicated to the employees, such as notice of eligibility and rights and responsibilities, designation notice, and certifications of healthcare provider for serious health condition and military family leave. Now, these forms were actually designed after seeking comments in 2019 regarding modifications to these forms. They're electronically fillable PDFs that can be saved electronically. So they have the appearance to try to make it easier for employers to utilize, but again, they're not mandatory at this point. They remain optional. Next slide. Another thing that the DOL has recently done is the independent contractor proposed regulations. As many of you know, excuse me, joint employer, independent contractor, all of those issues are at the front of many, many employment discussions right now. So the DOL has issued some proposed regulations designed to make it easier for companies to determine whether workers can be classified as an independent contractor. Now, the Department of Labor proposed an economic reality test to determine whether a worker is an employee or an independent contractor under the FLSA. Now, this test considers whether a worker is in the business for themselves or is economically dependent on a putative employer for work. So in doing so, they set two core factors to evaluate that. They include the nature and degree of the worker's control over the work, as well as the worker's opportunity for profit or loss based on initiative and or investment. Now, after these two core factors are evaluated and considered, there are three additional factors that will serve as guideposts according to the DOL. And these factors include the amount of skill required for the work, the degree of permanence of the working relationship between the worker and the potential employer, and whether the work is part of an integrated unit of production. So interestingly, the DOL has been seeking comments on these proposed regulations, and it actually stopped taking comments as of today. So I do anticipate and suspect that this issue will remain in the news, not only for this issue, but for some that we will continue discussing in the future. Next slide. The DOL has also issued some updates on the fluctuating work week, noting that it can be used to compute overtime if an employee's hours vary from week to week, as well as if other factors are met. They issued an opinion letter dated August 31st, 2020, clarifying that an employee's hours do not need to fluctuate above and below 40 hours per week to use this method of calculation. Next slide, please. And lastly, they updated their thresholds for executive, administrative, and professional employees under the FLSA. It is now 684. It was previously 455. And it also changed the highly compensated employees, which used to be $100,000. It is now $107,432 for the salary basis. Next slide.
As you may be all aware, in April, the NLRB issued its final rule concerning the issue of joint employer. Next slide, please. Next slide, please. In 2015, the NLRB issued its ruling in the case of Browning Ferris Industries of California, holding for the first time that an entity must exercise direct and immediate control over the essential terms and conditions of an employment of an entity's employees to be a joint employer. The board also held that indirect control or unexercised contractually reserved control alone could not be enough. In terms of looking at the indirect control factors, however, the board did not go into those issues. On appeal in 2018, the Court of Appeal held that unexercised reserve control or indirect control, analyzed as to the essential terms and conditions of employment, can be relevant factors in determining whether the entity is a joint employer. So in April of this year, the NLRB issued its final rule concerning joint employers. Next slide, please. The joint employer rule provides that an employer can be found to be a joint employer if that employer shares or co-determines the employee's essential terms of conditions of employment. The entity must possess or exercise such substantial direct and immediate control over one or more of the essential terms or conditions of the employment as would warrant finding the entity meaningfully affects matters relating to the employment relationship as to those employees. Next slide, please. The board also, in the final rule, sought to define and address issues of indirect control, contractually reserved but never exercised control, and an entity's control over mandatory subjects of bargaining. This would address, the third issue would address such situations where one employer hires another employer and then determines things such as where the work will occur and the time at which the work will occur. Based upon these factors, the analysis of the joint employer status is based upon a totality of the relevant facts, and the burden is always on the person or entity asserting that the defendant is a joint employer to prove joint employment. In terms of the necessary terms of conditions of employment, next slide, please. The board defined essential terms and conditions of employment as to mean wages, benefits, hours of work, hiring, discharge, discipline, supervision, and direction. In the final rule, the board then went through and addressed each one of these essential terms and conditions in terms of what was involved and whether or not the entity was a direct employer. Next slide, please. Direct or immediate control means with respect to each respective essential term or condition. And this is where the rule goes through the terms and conditions. Wages. The entity must actually determine the wage rates, salary, or other rates of pay that is to be paid to another employer's individual employees or job classifications. And as you see, as you'll go through these slides, the rule addresses each one of the essential terms and conditions of employment, describes the requirement of the employer to actually determine those terms and conditions. And then with respect to each one of these terms and conditions, adds a sub-statement, or excuse me, a parenthetical statement defining or further clarifying what each one of these terms means. So for example, wages. Next slide, please. Benefits. The employer actually determines the fringe benefits. Next slide, please. Hours of work. Actually determines the hours of work. Next slide, please. Hiring. Next slide, please. Discharge. Next slide, please. Discipline. Next slide, please. Direction. Next slide, please. The rule goes on to define the term substantial, direct, and immediate control. Means direct or immediate control that has a regular or continuous consequential effect on the essential term or conditions of employment of another employees, of another employees. The rule also goes on to define specifically indirect control and contractually reserved authority over essential terms or conditions. Next slide, please. Next slide, please. The final rule has not yet been the subject of any court decision as far as we're presently aware. However, it does add some greater structure to the analysis of the joint employer requirements or joint employer final rule. Next slide.
All right, now we're moving on to the California legal update. As it says right on this slide, so much in so little time. So here we go. Next slide. Next slide again. Just a brief, quick update on minimum wage. It's increasing as of January 1st. To $14 an hour for workers at businesses with more than 25 employees and $13 an hour for businesses with 25 or fewer employees. I have attached a chart on the next few pages that have all the different minimum wages, so you can look for the areas where you have businesses. The only issue that has come up with regards to the minimum wage is because of the pandemic, they have inquired with Newsom if he'd be willing to hold off, but it does not seem that he is willing to do so. So the increase is set to be effective in January. Next slide.
There have been a number of new rules that have been issued, new rules and laws and regulations. One of them that has been signed into law is SB 1384. Previously, the law provided that the labor commissioner could provide counsel to individual employees, indigent employees, in wage and hour cases involving the labor commissioner's order and arbitration claims. This law, SB 1384, expands the circumstances in which the labor commissioner is to provide representation to an employee facing a petition to compel arbitration, or an employee who has prevailed with respect to an arbitration, or excuse me, with respect to a labor commissioner order and faces an arbitration. Under certain circumstances, largely dependent upon the financial wherewithal of the individual, the labor commissioner will provide counsel to represent the individual concerning the arbitration award. Next slide, please. Another new law is the AB 1512, which was a decision, or excuse me, a law that was passed with respect to on-call rest breaks for the security industry. This law was passed in response to the case of Augustus versus ABM Security Services, which found that security guards could not be required to take on-call paid breaks, which would require them to stay in touch with their employer and have some means of communication. This law provides that security industry businesses can require their unionized employees to take on-call rest breaks. Next slide, please.
AB 5. Who has not heard of AB 5? Next slide. So we all know that in 2018, the California Supreme Court issued the Dynemex decision, which adopted the ABC test in order to determine if an employee is an employee or an independent contractor. I should have said if a worker is. Despite that holding, we have continued to be in flux with regards to the independent contractor argument, and it remains steadfast in the news. We now have AB 5, we have AB 2257, we also have Proposition 22. In essence, the ABC test has 3 factors in order to determine if someone is an independent contractor or an employee. And it involves being free from control and direction, outside the usual course of the hiring entity's business, or if the worker is customarily engaged in independently established trade, occupation, or business. Next slide. So after the Dynemex case came down, AB 5 was basically adopted. They adopted the Dynemex standard and it became effective on 1/1/20. And as all of us know, it makes it much harder for an employer in California to have an independent contractor. Now, when it was first effective on 1/1/20, AB 5 applied to California's labor and unemployment insurance codes, but it did not apply to California workers' compensation until July 1st of this year. So at this point, AB 5 is still being litigated by the courts, as there are numerous industries that are seeking exemption to AB 5. Next slide. So the various industries that are really at the height of this include truck drivers and gig economy workers. There are other ones that are still involved, but not so much as we've seen with the other 2. Next slide. So now we have AB 2257, which provided additional exemptions to AB 5. The law was just passed and it became effective immediately, and it provides for further exemptions from AB 5, including, and these are by no means are inclusive because there is so much information on these. I will tell you that AB 2257 can be a 1-hour webinar in and of itself. So if you do have any questions, please feel free to reach out. But the exemptions that 2257 have basically instituted include business-to-business exemption, referral agency exemption, professional services exemption, next slide, sound recording musical composition exemption, construction subcontractor, data aggregator, specific occupation exemptions such as freelance writers, fine artists, translators, editors, etc., real estate appraisers and home inspectors, as well as motor club exemption. Next slide. Now we have AB 5 and gig economy workers. As many of us have heard from the news, Uber and Lyft, DoorDash, all of those have disagreed with AB 5 and they requested an exemption, but they do not have one to date. Now, the Attorney General for the state of California brought an action on behalf of the people earlier this year, seeking a preliminary injunction against Uber and Lyft that restrains them from classifying their drivers as independent contractors. Now, this was granted on August 10th, 2020, and to no surprise, Uber and Lyft appealed. Just last week, on October 22nd, the California Court of Appeals upheld the preliminary injunction that the lower court had issued. Next slide. So where does that leave us now? As we know, in California, Proposition 22 is on the ballot for next week. And Proposition 22 would consider app-based drivers to be independent contractors and not employees or agents. Therefore, the ballot measure would override AB 5 as it relates to basically Uber and Lyft with regards to app-based drivers. So for now, we have to wait until Election Day to see what happens with Proposition 22 and how AB 5 will apply to Uber and Lyft drivers and other gig economy workers perhaps as well. Next slide.
This is a quick update concerning the California Consumer Privacy Act. As many of you may know, the California Consumer Privacy Act is an act enacted to protect consumers' private personal information. Next slide, please. It is directed at businesses that collect and sell private information concerning consumers. Next slide, please. This slide describes the entities that have to comply with the act. The significance of the amendment or the expansion is that it extends an exemption. Next slide, please. It extends an employer exemption under the Privacy Act to the end of 2020, which means that those businesses, there's an exemption for personal information in the employment context that is used in the employment context, and also consumer information in business-to-business communications, where the consumer is acting on behalf of the business in a transaction. Next slide, please.
We're going to talk a little bit about family leave updates. Next slide. The main one that has recently been passed, which unfortunately is not great for employers, especially small employers, is SB 1383. It expands CIFRA to small employers of 5 or more employees. Now, previously, it did not apply to employers with fewer than 50 employees. So it's a big change in reference to what it covers. Now that it's been expanded, it allows all those employees, if they are eligible, having 12 months with the employer or working 1,250 hours in the previous 12-month period, and they can take up to 12 weeks of unpaid leave during any 12-month period. Now, the changes that this really affects are twofold, in my opinion. Next slide. One, the leave has expanded. So it used to be basically child, parent, spouse, or domestic partner. Now they've added adult children, grandparent, grandchild, sibling. So there's more reasons for the leave to happen. Next slide. The other big change is that if the employer employs both parents, this new law has gotten rid of the exemption that you could only have 12 weeks between the two parents. Now you have 12 weeks for each parent. So that could obviously be quite hard for smaller employers to deal with if they have both parents working for them. And I thought the other thing that is very important to note is that CIFRA may or may not run concurrently with the FMLA anymore because of the differences. So it is possible that leave could be even extended longer than 12 weeks, depending. Next slide, please. AB 2017 was also just passed. This is effective on 1/1/21, and it basically provides employees the sole discretion to designate days taken as paid sick leave to attend to the illness of a family member. Next slide.
Next slide. This is a significant new law that was passed and signed into law. AB 1947 in California extends the time for a claim to the Labor Commissioner under Labor Code Section 98.7, and also provides for an award of attorney's fees in Section 1002.5 whistleblower cases. The significance is it now gives the employee an additional 6 months in which to file a claim to the Labor Commissioner, and more significantly, the award of attorney's fees under Section 1102.5 incentivizes, once again, as we know, labor code violation claims. So the import of this law is that it gives the individual employee more time to determine whether or not to file a claim, and on top of that, possibly get an award of their attorney's fees in a whistleblower claim. Next slide, please. A couple of years ago, you may recall that the legislature and the governor enacted in law a requirement that there could not be no new hire provisions in settlement agreements. Well, the law did contain an exception, and that was where the individual claimant, the aggrieved employee, had been charged or accused of sexual harassment, sexual assault, or criminal behavior. So the law retains the right to put a no hire provision, no rehire provision in a settlement agreement, but it tightens up the requirements for the employer to make a good faith determination and document the fact that there was sexual harassment, a sexual assault, or criminal conduct before the employee filed their employment claim. Next slide, please. SB 973, which becomes effective in 2021, requires employers to submit reports to the Department of Fair Employment and Housing. The reports would include things as the number of employees by race, gender, ethnicity, and certain types of job categories. The reports also will have to address pay issues. The intent of the law is to identify and fight discrimination in pay practices. Attorneys advising employers with hundreds or more now must be aware of an additional reporting requirement for their clients. Next slide, please.
And last but not least, COVID-19, where we are right now today. Next slide. There have been a few things that have come up. One, I just wanted to make sure you all are aware of the COVID-19 playbook that the state of California has put out. Details safe return to the workplace, reporting guidelines, paid sick leave guidelines. The site there is for you to reference. Next slide. Then we have a couple new laws that have been passed. AB 1867 is basically the supplemental paid sick leave. It really was designed to counteract with the FFCRA. So the FFCRA, as we know, applies to employers with less than 500 employees. This AB 1867 applies to employers with more than 500 employees. So this law is effective until December 31st of 2020, or at the expiration of the federal extension of the FFCRA, whichever occurs later. Next slide. As indicated, it's designed to fill the gaps left by the federal law, but specifically it covers food service workers and the healthcare providers or emergency responders whose employer had elected, which they could do, to exclude them from the EPSL under the FFCRA, in addition to anyone who's required to self-quarantine or self-isolate. Next slide, please. Then we have AB 685, which was signed on September 17th and is effective on 1/1/21. It expands Cal OSHA's authority to issue stop work orders for workplaces that basically are either not complying with CDC guidelines, who have outbreaks, and are posing a risk of imminent harm. It also adds notice requirements to employers when there is potential exposure. Next slide. So what does the employer need to do? So within 1 business day of receiving a notice of potential exposure, an employer must do these 4 things. And we're running out of time, so I'm going to just quickly summarize them, and they will be on the slide with more detail. But you need to provide written notice to all employees that may have been close to the person who has been infected, basically who may have been exposed, possibly to their representatives, unions or lawyers. You also have to advise them of their rights, workers' compensation, paid sick leave, etc., as well as letting them know what the company's CDC compliant protocols are for disinfection and safety plan to eliminate further exposure. Next slide.
AB 2537 creates specific requirements regarding general acute care hospital and supply personal protective equipment. Its purpose is to protect the healthcare workers from COVID-19. The law requires the implicated critical care hospitals to maintain specific stockpiles of specified respirators, particulate filters or cartridges, surgical masks, isolation gowns, eye protection, and shoe coverings. In addition to maintaining the stock, it has to be a 3-month supply of the specific equipment. The law also requires that the hospital keep a record, and there's a $25,000 civil penalty for not complying. Next slide.
We're going to end with SB 1159. It's the rebuttable presumption of industrial causation due to COVID. It's an emergency bill, so it was effective as of September 17th, the day it was signed, and it's effective through January 1st of 2023. Basically, SB 1159 codified Executive Order N6220, which created the rebuttable presumption for industrial causation. Now, the initial executive order applied to all employees, all kind of workers. It ended on July 5th of 2020. Now, SB 1159 is a rebuttable presumption that's extended from July 6th, 2020 onward, but specifically for basically frontline workers, firefighters, peace officers, healthcare workers, in-home supportive care providers. And basically what it says is that if one of these employees is diagnosed with COVID-19, it is presumed compensable under the workers' compensation laws of California. And it has to be done within 14 days after reporting to the workplace during while they were employed at the employer's direction. The second part of 1159 is for the non-frontline workers. And for them to have the presumption, they need to have been directed to report to work, and they needed to have been at work within 14 days of an outbreak. Now, the outbreak has multiple definitions depending on what you are as an employer. For instance, if you're an employer with 100 or less employees at a specific work site, if you have 4 employees test positive, you have an outbreak. If you have more than 100 employees and you have more than 4% of your employees at a specific workplace test positive, that is an outbreak. And then, of course, if you're closed by any one of the safety departments, you could be determined to have an outbreak as well. Next slide. Now, in reference to the rebuttable presumption, the employer does have 30 days in which to rebut the presumption. That means any evidence that you have found must be located within those 30 days to deny the claim. If you find it after 30 days, you can try to use it, but chances are you're going to be stuck with the presumption. Now, an employee must exhaust any COVID-19 supplemental paid sick leave before collecting any TTD benefits if owed. The date of injury is considered the last day that employee worked at the place of employment at the employer's direction prior to the positive test. But because of COVID-19 and the pandemic, one of the important things to note that a person's own home, the employee's home or residence, is not included in this. It has to be at the direction of the employer at the employer's work site. The only exception to this are the people who provide in-home support services. Next slide. Now, 1159 created employer reporting requirements, and I think this is the most important thing that you all need to know. Now, when you know or reasonably should know that an employee has tested positive, you must do a few things. You have to advise your claims administrator in writing, and it's between email or fax, within 3 business days of the following information. You need to note that the employee had a positive COVID-19 test. Now, you're not supposed to put any identifying data other than the employee had a positive COVID-19 test. The exception is when they are already making a claim for workers' compensation benefits. 2, you need to state the date that the employee tested positive, which is the date the specimen was collected. 3, You need to note the address or addresses of where that employee worked on site at the place of employment during the 14 days preceding the date of the positive test. Going back to the outbreak, if that person was in multiple facilities, that number would attach to each of those facilities. And lastly, you need to report the highest number of employees who reported to work at the employee's specific place of employment in the 40-day period preceding the last day that that employee worked at each specific place of employment. Next slide.
Thank you once again, Melissa and David. Have a great day, everyone.
Thank you all. Have a great rest of your day.
Thank you.